to our panel, When Rights Collide, Religious Liberty, Equality, and the Fallout from Hobby Lobby. I'm Joan Biskupic. I work at Reuters, and I've covered the court for about 25 years. As we're awaiting major rulings related to the Affordable Care Act and also on same-sex marriage, Hobby Lobby is a backdrop for a lot of things that will come in the fallout to those two rulings. And that's what we're going to explore today. First, a couple bookkeeping things before I introduce my fellow panelists. Make sure everybody has their cell phones off. We're going to leave about 20 minutes for questions afterward. And because this is being taped, we'd like everybody to wait before asking the question to get the mic to them. This is CLE credit, so know that you can take advantage of that. And if you tweet, I've been told that the Twitter handle for ACS is ACS Law, and the convention's official hashtag is ACS15. For those of you who haven't been covering the court 25 years and who are younger and ready to tweet. I'm joined today by a terrific array that will give us a broad understanding of Hobby Lobby and some of the fallout. Immediately to my left is Doug Laycock, who is the Robert E. Scott Distinguished Professor of Law at the University of Virginia. He is a professor of religious studies, and his expertise, of course, is in the Free Exercise Clause, religious liberty legislation, and the Establishment Clause. He has urged the Supreme Court to find a constitutional right to same-sex marriage and then to protect the religious liberty of dissenters. He's also appropriate for another issue that we're awaiting at the Supreme Court, affirmative action on campuses. We'll actually know soon if they're going to retake the Fisher case. Doug has also been involved in that. And he's played a key role in developing state and federal religious liberty legislation. Next to him is Kent Greenfield, a professor of law and Dean's Research Scholar at Boston College Law School. I should tell you that there are more elaborate bios in your packages, but I just want to at least give a little backdrop to where they'll be coming from in their remarks. He teaches corporate law, and he is a former clerk to David Souter. Next to him is Doug Nejame, who right now is a professor at the University of California at Irvine, and he teaches in areas of family law and sexuality, as well as constitutional law. And finally, Kelly Garcia, who is with the National Women's Law Center. She's senior counsel there, and she'll be especially addressing religious restrictions on women's access to reproductive health and looking at things that arise from hospital mergers and crisis pregnancy centers, giving us the state lay of the land. It's interesting to think that so much has happened since last June 30th when Burwell versus Hobby Lobby was handed down. I'll just briefly remind everyone what that said, and then we're going to go immediately to Doug Laycock. 5-4, a very familiar lineup with Justice Alito writing the decision. Obviously a test of the Religious Freedom Restoration Act brought by owners of a closely held for-profit corporation. And what he said was that the plain terms of RFRA make it perfectly clear that Congress did not discriminate against the men and women who wish to work and run their own businesses and for-profit corporations. And he highlighted, of course, the alternative in the ACA regulations to enforce the government's aims of the contraceptive mandate. He was joined by Chief Justice John Roberts, Antonin Scalia, Clarence Thomas, and Anthony Kennedy. Anthony Kennedy wrote separately to talk about how narrow the ruling actually was, and that will be part of what we discuss here, narrow or broad. Dissenting were Ruth Bader Ginsburg, our senior liberal, and Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan, talking about the startling breadth of the ruling. And again, that's one of the things we'll be talking about, and I just could tell that Doug Laycock just scoffed when I referred to the startling breadth of the ruling. But before you get to that, take us back as far as you think we need to go, either 1993 for RFRA or even 1963 with Sherbert, to give us a little bit of a backdrop of how we got to this point.
Well, when the Supreme Court said in 1990 that the Free Exercise Clause does not protect religious conduct except against some kinds of discrimination, but doesn't require government to demonstrate any reason whatever for interfering with religious practice, the civil liberties community was shocked and outraged, and RFRA passed with overwhelming bipartisan support unanimously in the House, 97 to 3 in the Senate, and the three were only unhappy about not excluding prisons. There was, and you know, all the religious groups supported, of course, but so did the ACLU and Americans United for Separation of Church and State and People for the American Way. It was a wall-to-wall, religious, secular, liberal, conservative coalition. Ted Kennedy was a lead sponsor in the Senate. Bill Clinton was enthusiastically in support and happily signed it. Protecting businesses was not a live issue in the years that RFRA was debated. Nobody thought about it much, although someone apparently did. There are two things that cast light on the issue of protection for businesses from the history of RFRA. One was the commitment was a single universal principle, no exceptions. The reason it took 3 years to enact was they stared down the demand for an abortion exception. There would be no exceptions, and no one said no exceptions for businesses, but the principle was no exceptions. And second, at least somebody was thinking about businesses, because the first year it was introduced, there was a definition of person. It didn't rely on the Dictionary Act. RFRA defined person for itself, and it defined person to mean a natural person or a nonprofit religious organization. That was taken out of all later definitions, or all later drafts, all later bills. So all the later bills relied on the general definition of person in the Dictionary Act that clearly includes corporations. The Supreme Court struck it down as applied to the states in 1997, left it in effect as applied to the federal government. Congress tried to replace it, but by this time the coalition had broken down principally over issues of gay rights, and the gay rights groups organized the civil rights community more broadly to demand a total carve-out for all civil rights claims, which the supporters were unwilling to grant. Mr. Nadler, who had been one of the original sponsors of RFRA in the House, tried to solve that impasse with an amendment. The Nadler amendment would have said everybody's protected, including business corporations, if the claim is not a civil rights claim. Nobody's protected against a public accommodations law. Very small employers are protected against employment discrimination laws. Entities that are exempt from the Federal Fair Housing Act are protected from state and local fair housing laws. There was a major debate on that amendment in the House, and it was common ground on both sides. The language as it stood, the language that had been copied directly from RFRA, covered business corporations. The Democrats said Exxon could have a claim, and the Republicans didn't deny that. They said Exxon's in the bill, but Exxon will never have a claim. It was ridiculous. It was common ground that the language in RFRA covered business corporations. Congress also provided religious liberty exemptions for businesses in other contexts, and so have state legislatures. All the abortion conscience legislation around the country protects for-profit medical practices and hospitals. The states that have assisted suicide by legislation exempt medical practitioners, exempt hospitals, exempt hospices who claim conscience objection. For-profits are exempted. The kosher slaughter laws have always exempted for-profit slaughterhouses from other kinds of slaughter regulations. There's been an escalation, and you often hear from my friends on the progressive side, the religious side has escalated. No one ever claimed religious exemptions for businesses before. Now they're claiming it. Well, they haven't come up very often, but they have come up, as I just said. But the escalation here, I think, came from the secular side. Never before in American history have we attempted to make illegal, under any circumstances, well-known core religious practices of the largest religious groups in the country, right? Free exercise litigation has been about small and marginal groups. It has been about incidental regulation of major churches, but with respect to the contraception mandate and with respect to same-sex marriage, we have made in certain contexts illegal practices of nearly half the population, all the Catholics and evangelicals. That's new, that's unprecedented, and it produces a new level of litigation that we haven't seen before. The Greens, who own Hobby Lobby, own it, direct it, manage it. Hobby Lobby can't do anything unless some green authorizes it to be done. They feel morally responsible for what the company does. And in general, we hold the managers of corporations and the owners of closely held corporations morally responsible for what the company does, except for the kind of special pleading that we've heard with respect to Hobby Lobby. If the Greens, if Hobby Lobby's affiliate that sells Christian books sold child porn instead, nobody would say the Greens are not responsible for that. The people who own and manage the corporation are responsible for what the corporation does, and the Greens say, we believe we are being asked to pay to kill babies. And nobody in this room agrees with that. I don't agree with that, but that's what they believe. And no one on our side has taken that belief seriously. If you believe you're being asked to kill babies, that's not something on which you can compromise. That is a very serious moral violation. That was their position. The court's opinion in Hobby Lobby didn't rely on that. It pretty clearly applies to ordinary contraception as well as emergency contraception. But the facts that were at issue, what the Greens believed they were being asked to do, was to pay to kill babies. Finally, this is a very narrow opinion. The court relied on the accommodation that the government had already arranged for religious nonprofit entities, which is too complicated to explain in 5 minutes, but which enables female employees to get free contraception and free emergency contraception from the insurance company, segregated funds and segregated communications without the employer having to pay for it, arrange for it, or contract for it. And Justice Alito's opinion says the impact on female employees will be precisely zero. If we had a case where the employees had to actually do without, that would be a different case. It is not covered by Hobby Lobby. Some of the hardline conservatives would probably vote that the employees have to do without. But if you read the Kennedy concurrence, I think it's reasonably clear Kennedy is not prepared to vote that the employees have to do without. But however that case comes out down the road, I think the government and the employees are going to win. But however that comes out was not decided in Hobby Lobby. So I think Hobby Lobby is a very narrow decision in response to an extraordinary regulation that provoked an extraordinary degree of religious and moral resistance. And harder issues down the road just haven't been reached yet. And there are going to be very few other medical treatments that have this feature of contraception. That providing contraception pays for itself, so you can make the insurers do it without compensation, and the government's position is they're going to come out even. So it's an odd set of facts. It takes the RFRA seriously. There have not been many corporate claims in the past. There are not going to be many corporate claims in the future. But here's a corporate claim that won, and I think that deserved to win.
Thank you very much, and that's a perfect segue into Kent. First of all, I know you're going to look at corporations specifically, but what do you think of the contention that this really is a narrow ruling, that Kennedy's voice will prevail down the road as opposed to Justice Ginsburg's?
I hope Doug is right, but I don't think he is in this respect. Because the way the opinion was written is that it applies to not just closely held, not just family-owned, but all corporations, and not just with regard to this contraceptive mandate, but also with regard to any other thing that the shareholder owners, so-called, could have a legitimate religious claim for. So let me say a little bit about my take on the Hobby Lobby case, and I think the statutory argument really was, or the statutory question was, whether corporations could be considered persons for purposes of RFRA. And at first glance, what the court did was to accept corporate personhood. Now, the reality is that the ruling was a rejection of corporate personhood, and the right answer would have been derived if the court had recognized personhood as a matter of corporate law, because that would have led it to reject personhood for corporations under RFRA. Now, let me explain what I mean. Even though it was a statutory case, it came in the form of an unconstitutional conditions case, The question, in taking the Greens' claim seriously, what they say is that, look, it is an unconstitutional, it's not a constitutional question, I understand that, but the form of their argument is, it is impermissible for the government to condition our enjoyment of the corporate form on us waiving our religious freedom. And in other words, must they give up the exercise of their religious rights as a condition of incorporation? Now, in that way, you could see the Hobby Lobby ruling as just one of the series of Roberts Court's rulings on unconstitutional conditions. And Roberts is pretty stingy in the unconstitutional conditions doctrine. We see that in Sebelius, we see that in the USAID case, we see that in Kuntz from last year. And basically, my understanding of, and this is a doctrinal thicket, right? But if you wanted to bushwhack it, the way Roberts does, what Roberts says is conditions tend to be okay if they define the scope of the right, or the scope of the governmental funding or privilege, and not permissible if they go beyond the scope of the funding. Now, if that's the question, I think Hobby Lobby comes out incorrectly because of a corporate law insight. Does the nature of the government benefit, the privilege of incorporation, have anything to do with the shareholders' religious rights? And a bunch of us corporate law professors filed an amicus brief in the case arguing that the very purpose of the corporate form is to separate the shareholders from the entity, right? In other words, to recognize corporate personhood. Personhood in this setting means separateness, right? So the very meaning of corporate personhood, as a matter of state law, corporate law, is to separate shareholders from the corporation. So what the Greens wanted was to separate their own personal liability from and status from the corporation for their own protection, but to have the corporation carry forward their own religious exercise rights. And I don't think you can have one without the other. So in a way, the question ought to have been, is it the proper understanding of Oklahoma state corporate law to require the Greens to give up their unity with the corporation? And I think the right answer as a matter of corporate law would have been that yes, they are not the same. So it's not really the question of whether corporations can be religious, but whether corporations can carry the religious rights of their shareholders. Now, the opinion was couched about a family corporation and closely held, but remember that Alito, in his opinion, said, no known understanding of the term person includes some, but not all corporations. So even though it was about a family-run company, about a closely held company, he does not limit his rationale to those kinds of corporations. And even if he did, closed corporations include corporations like Dell, Aramark, Cargill, Koch Industries, right? According to Fortune, the 441 largest closely held corporations employ about 6 million employees with $1.8 trillion in revenue. So even if it applies just to closely held companies, we've got a lot of companies that could be making these claims. And if we add to that the corporations that are dominated by one or two shareholders, that sweeps in companies like Nike, Tyson Foods, Walmart. The Walton family owns over about 50% of Walmart stock, and Google. So, in my view, what Hobby Lobby got wrong was to ignore corporate personhood, and I think that was the fundamental mistake of the opinion.
I'm gonna have Doug respond, but first I have a question about the idea that some of these larger corporations could rely on Hobby Lobby. What kind of scenarios do you think you'd see? I presume we haven't seen anything yet, but under what kind of scenarios?
Right. So, and in this respect, maybe I hope Doug is right, but the only thing in Alito's opinion that said that they could not bring it was just a practical matter, that there was no way that the shareholders would be able to agree on this. But I'm not sure that's right. Let's imagine, let's say that that INDA passes, right? And INDA, a federal law, requires employers not to discriminate on the basis of sexual orientation. I could imagine Koch Industries, for example, which is a multi-billion-dollar corporation, or maybe not Walmart these days, but at a certain point in time, maybe Chick-fil-A, right? Chick-fil-A, they could easily say that as a matter of corporate purpose, we've got two purposes: excellent chicken sandwiches and traditional marriage, right? So that could, especially after Hobby Lobby, those kinds of claims are at least a possibility.
Doug, as a theoretical matter and also a practical matter, what do you think?
Well, as a theoretical matter, anything can happen. As a practical matter, there are enormous pressures not to create such claims, both from the consumer reaction, from your investor reaction. The Health and Human Services, which is not sympathetic to Hobby Lobby, in its proposed rulemaking to expand the regulations in response to Hobby Lobby, estimates that there will be 71 for-profit claims. I have no idea how they estimated that. They might have pulled it out of their ear. But it's the right order of magnitude, right? The court had never said corporations aren't covered. It never said businesses aren't covered. There have been very few claims. Businesses have never won one of those claims. Hobby Lobby is the rare case where the business wins. The court didn't say the commercial context was irrelevant or that it didn't matter or the commercial case claims are going to win very often. I think there are just not going to be very many claims. And as Chris Lund at Wayne State likes to point out, in Corporation of the Presiding Bishop versus Amos in 1987, the issue of for-profit businesses claiming to be religious organizations was very much on the table. All the separate opinions talked about it. They didn't resolve it. It was like an invitation to bring those claims. There's been one in the ensuing 28 years.
Well, at the time of Hobby Lobby, there were about 50 or 60 claims in the lower courts. And Hobby Lobby itself, right, is a company of 500 stores, about 20,000 employees. So you multiply that, even if you multiply that by 50, that's a significant number of impacts.
It sounds like your point is that the way the opinion is written, it doesn't necessarily bar it, but for all practical purposes, it's not going to happen.
That's right.
Yeah. We'll turn to Doug Niejaim now, whose take on this is interesting, looking at what he calls complicity claims. People who are seeking objections from laws, exemptions from laws, based on the notion that they would be complicit in assertedly sinful conduct of others. And why don't you explore that a little bit, Doug?
Yeah, thanks, Joan, and thanks for moderating us. You did a great job putting this all together and getting us to have a panel where we covered a lot of territory. And I'm going to be specifically speaking from work I've been doing with Reva Siegel on the issues surrounding Hobby Lobby and related conflicts, and introducing this notion of complicity claims. So up till now, the discussion has been focused on the claimant, and I'm going to shift the focus to thinking about the form of the claim. So today's conflicts over healthcare and marriage feature a kind of religious liberty claim in which the claimant objects to being made complicit in the sins of others. So the employers in Hobby Lobby objected that the ACA forced them to, quote, provide insurance coverage for items that risk killing an embryo and thereby makes them complicit in abortion. And similarly, in the wedding industry, businesses are objecting to, quote, facilitating same-sex wedding ceremonies. Complicity claims don't appear in the cases invoked in RFRA, Sherbert, which Joan mentioned, Yoder involving the Amish, and mandatory compulsory school laws, and Smith, the Native American peyote case. But complicity claims do have a rich history in another religious liberties tradition, legislative tradition, healthcare refusal laws, which Doug briefly mentioned. Federal and state laws enacted in the wake of Roe v. Wade authorized doctors with religious or moral objections to refuse to perform abortion or sterilization. And over time, abortion opponents invoked religious liberty to greatly expand these healthcare refusal laws, authorizing many more individuals and institutions to object to healthcare services they deem sinful, prominently abortion, but increasingly also contraception. And this new generation of healthcare refusal laws use concepts of complicity to authorize religious objections in a much wider range of circumstances. I'm just going to offer one illustration from Mississippi. The state allows healthcare providers to assert conscious objections to providing, quote, any phase of patient medical care, treatment, or procedure, including but not limited to the following: patient referral, counseling, therapy, testing, diagnosis or prognosis, research, instruction, prescribing, dispensing or administering any device, drug or medication, surgery, or any other care or treatment rendered by healthcare providers or healthcare institutions. And it defines healthcare provider as expansively as possible. Quote, any individual who may be asked to participate in any way in a healthcare service, including but not limited to a physician, physician's assistant, nurse, nurse's aide, medical assistant, hospital employee, clinic employee, nursing home employee, pharmacist, pharmacy employee, researcher, medical or nursing school faculty, student or employee, counselor, social worker, or any professional, paraprofessional, or any other person who furnishes or assists in the furnishing of a healthcare procedure. Healthcare refusal laws have now expanded to include people and institutions related by all manner of financial relationship, including through mergers, HMOs, and insurance. The complicity-based objections in Hobby Lobby likely descended from these kinds of healthcare refusal objections. There are two important things I want to observe about healthcare refusals legislation. The first is that accommodation of conscience claims in this context rarely mediates the impact on third parties, namely women seeking access to abortion or contraception. So a system of healthcare delivery can accommodate the conscience objections of healthcare providers while also ensuring alternative care for patients. But some laws authorize refusals, but rarely require institutions to provide alternative care. And many authorize providers to refuse to notify patients that they've been denied care in which they may be interested. Accordingly, the second thing to observe is that expansive healthcare refusal laws of the kind Mississippi has enacted function to restrict access to abortion. Mississippi's law is based explicitly on the Healthcare Freedom of Conscience Act promulgated by Americans United for Life, a leading anti-abortion organization that drafts model legislation for state lawmakers seeking to curtail abortion rights. Healthcare refusal laws now offer a model for opponents of same-sex marriage and LGBT equality facing the prospect of a Supreme Court defeat. So Ryan Anderson, who's written a lot on this from the Heritage Foundation, wrote in the National Review, quote, court-imposed same-sex marriage via a Roe-style decision will not settle the marriage debate any more than it settled the abortion debate. Whatever the court does will cause less damage if we highlight the importance of religious liberty. Even if the court were to redefine marriage, government shouldn't require third parties to recognize a same-sex relationship as a marriage. Okay, so we have a rich history of complicity claims in the healthcare context. Those are being, we see sort of the roots of Hobby Lobby there, and we also see them being deployed in the marriage context. So why are we singling out complicity claims as special? Well, complicity claims concern the conduct of third parties, other citizens who don't share the objector's beliefs, and so we argue differ in some fundamental ways from other religious liberty claims. For instance, in the recently decided Holt versus Hobbs case handled by Professor Laycock, a prisoner sought a religious exemption from the prison's prohibition on beards. He wasn't seeking to avoid complicity in what he believed were someone else's sinful acts. To be sure, complicity claims are bona fide faith claims. There's a rich Catholic tradition that uses principles of cooperation and scandal to warn against complicity in the sins of others. And also, RFRA's language covers complicity claims. But complicity claims differ from the claims invoked in RFRA, and those differences matter not because they make the claim for religious exemption less authentic or sincere, but rather because accommodating claims of this kind has the potential to inflict targeted harm on third parties, such as women and same-sex couples. So in the free exercise cases that Congress invoked in passing RFRA, religious minorities sought exemptions based on unconventional beliefs, generally not considered by lawmakers when they adopted the challenge laws, and Doug talked about this a bit. The cost of accommodating their claims were minimal and were widely shared. The claimants in Smith, the peyote case, sought an exemption from drug laws that precluded them from engaging in ritual peyote use. The exemption they sought would have modestly detracted from the public health and safety interests advanced by the drug laws. Complicity claims are different. Because they focus on the conduct of others, accommodating the claims can harm those whose conduct the claimants view as sinful. And today, these claims are asserted by growing numbers of Americans about some of the most contentious culture war issues of our day, often encouraged by those seeking to mobilize faithful against laws that depart from traditional sexual morality in areas including sex, reproduction, and marriage. Complicity claims concerning these kinds of issues will increase in number, and their accommodation will have significance not only for the claimants, but also for those the claimants say are sinning. we're trying to show not only that the harms of accommodation should be central to legislative deliberations over complicity claims. So for instance, in healthcare refusal laws, that the impact on third parties should be mitigated, but also that such harms are in fact important to judicial application of RFRA. We're not questioning these complicity claims at the level of sincerity, and we're not even focusing on the front-end inquiry of RFRA, which asks whether there is a substantial burden on religious exercise. Though it's worth noting that issue has come up now in some of the Court of Appeals decisions in which religiously affiliated nonprofits are challenging the actual mechanisms of accommodation from the contraceptive coverage requirement. What we're focusing on is actually the back-end inquiry, the relationship between what we observe about complicity claims, their unique capacity to inflict third-party harm, and the compelling governmental interest and least restrictive means inquiry of RFRA. And third-party harm is relevant to that inquiry. I know Kelly will speak more about this, and I might chime in then, but I'm just going to say one thing now that actually resonates with some of the reading of Hobby Lobby that Professor Laycock gave us. The court has often limited accommodation out of a concern about third-party harm. And in fact, concern about third-party harm structured the court's decision and also animated part of Justice Kennedy's concurrence. The court did not hold that religious liberty trumped the government's interest in women's health, but instead recognized the claim for accommodation on the narrower ground that the government could promote women's access to contraception by means that did not burden the plaintiff's religious liberty. The majority found for the employers on these narrow tailoring grounds, and in fact opened by emphasizing, as Professor Laycock suggested, that their religious beliefs could be accommodated with precisely zero effect on their female employees, even if this assumption was incorrect, which I think we're going to hear about. The court's reasoning in Hobby Lobby shows how third-party harm is an integral part of the RFRA inquiry into whether enforcement of the law is the least restrictive means of furthering the government's compelling ends. I'll stop there, but what the animating principle is trying to understand the way in which the impact of accommodation, which is so important in understanding these complicity claims, actually is translated into the judicial application of RFRA, particularly around the governmental interest and narrow tailoring analysis. Thanks.
Great, thanks, Doug. And I think what we will do is quickly get Kelly's voice in here before we go back and forth on some questions, just because it's such a nice segue. Kelly?
Great, thank you. I really appreciate the opportunity to get to talk. I'm going to set my timer and try to move it over here so that I can keep track of time. This was actually a great segue, and I had kind of structured my talk, my presentation in one way, but I think I want to start in a slightly different place, which is to talk about, it's not a coincidence, it's not a surprise, it should not be shocking that we're seeing this unprecedented expansion of RFRA in the context of women's reproductive health. Because as Doug already pointed out, we have seen a series of laws and exemptions that were specifically targeted at allowing providers and then spreading from actual providers to kind of anyone who winds up touching on women's reproductive health care, being able to get out of those laws. And so what I wanted to do today was really center and focus on why women's concerns are important. What we saw in the court's decision is that the focus was on the corporations and the focus was on the employers, and women were largely left out of that conversation. So to start that, though, I'm going to take a step back and talk about some of the harms that we've seen to women when we've had laws that have allowed these broad religious refusals. So Illinois right now is in the process of trying to amend its Healthcare Right of Conscience Act. And so their act is also very broad. It does not it currently does not require referral. So if a woman is refused care, she doesn't have to get a referral. The hospital doesn't have to provide a referral, doesn't have to tell her she's being refused care. And what we see in cases when women are suffering, for example, miscarriages and go in to get care, they aren't told. They aren't told that you're suffering a miscarriage. They aren't told that their pregnancy isn't viable. Instead, they're sent away told to go home and come back if you start bleeding. This puts women's life in danger. This threatens their health. This threatens their fertility. And in Illinois, a woman came and she testified and she talked about how she went through a 6-week pregnancy loss because she couldn't get a referral, she couldn't get information, and then the hospital that was refusing to provide care actually refused to turn over her medical records. 6 6 weeks she was going through this. And this happens. This is not kind of a coincidence. This isn't a one-off thing. It's a horrible story, but it happens to women all the time, and it's hard to get those stories out because they're so painful. And so what we see what I want to say is we've already set up this context in this country. We've already started talking about and treating women's right and access to reproductive health care as something that we can exempt. And so it's really kind of not surprising that we saw this unprecedented expansion of RFRA in the exact context of women's reproductive rights. And I want to kind of frame and think about, as Doug said, in Alito's opinion, he stated that there's precisely 0 impact on women, but that's not really true, right? If you look at the way Ginsburg framed the issue, she notes that what's at stake for women is the right to access contraceptive coverage, to have full preventive care, access through your employer-based health plans. And one of the things that the Hobby Lobby decision does is it cordons off contraceptive care. It's another instance in which we're taking women's reproductive health care and pushing it off to the side and saying we can treat it differently. And so women are being denied a benefit in their health plans that is part of their compensation. It's part of what they have paid for through their own contributions to their health plans. And we're coordinating that off, and they're supposed to be getting it in another way. I will also say, and put off to the side, that they claim that there would be precisely 0 effect on women without actually interrogating whether or not it was true, without interrogating whether or not women would actually be able to access their reproductive health care, whether they actually would be able to get this benefit. And I can say we have a hotline at the National Women's Law Center where women are able to call in and talk to us and tell us to seek help if they're unable to access their contraceptives with no cost sharing. And we are getting calls from women who are having problems, whose employers are claiming are supposed to be going through the accommodation, and for whatever reasons they're unable to get care. And so it is not the case, right? It's not the case that it's seamless. And in fact, I'll just leave it there. It's not the case that it's seamless and the women are actually going to get the care. That is not necessarily the case. But we also cannot and should not discredit the fact that the idea that telling women you're going to have to get it in some other way, even if in theory it could actually be seamless, that is not a harm in and of itself, because we are telling women that they don't get to have the same compensation that the male employees do, and that is incredibly, incredibly problematic. I'm going to stop there because I think we've had a lot of things kind of to respond to. Oh, before I stop there, I do just want to say quickly, I can tell you there are 50 for-profit cases currently that have currently been filed, includes 4 that include both for-profit and nonprofit, and there are 43 nonprofit claims currently in the courts, again, kind of including those 4 that have both cases. So that's a lot. That is, in fact, a lot of cases, and I think we should kind of keep that in mind as well.
Thank you, Kelly. I want to follow on this immediate discussion, and then we'll talk a little bit about what might happen depending on how the Supreme Court rules in the same-sex marriage case, and then we'll be opening it up to all of you. But Doug, I thought I'd ask you to first respond, and then Kent and Doug Nijay might want to jump in too. Is Hobby Lobby sort of scapegoated in some way for how valid do you think the connection is between the scenario that Kelly sketched and what's really in the ruling?
Well, I don't think there's much connection. Some of the scenarios she sketched, I do not defend. The Mississippi exemption law goes too far. I don't think there's a religious liberty right to deceive your patients, or to withhold information or withhold a referral when you've got a monopoly on the information and it's not readily accessible. And some of the religious objectors are willing to make referrals and some are not, but I think the ones who are not would lose under a RFRA standard, and some of these state laws need to be amended. On Hobby Lobby itself, I've gone through the workaround, making the insurance company do it in detail. There's no reason that shouldn't work. Implementation any human plan is never perfect. The administration immediately proposed a new rulemaking to extend that to for-profits last summer. It hasn't been finalized yet. I don't know what's going on there. I'm not sure why it's taken so long. But I think when the dust settles, contraception will be available to the employees of these conscientiously objecting companies. The information will be coming to the female employees. They will be able to get it. They will not have to pay for it. And the symbolic effect that it's in a separate plan, I just don't think matches up against the conscience claims on the other side.
You know, Kelly, you mentioned the 54 claims. It's you're obviously seeing something different there. What state are they in? What kind of, have we seen much in terms of where the courts are going with this and how expansively they might be reading Hobby Lobby on these kind of claims?
So I think the courts have generally, we had a great decision out of, and I am completely blanking on my circuits at the moment. So Posner had a good decision kind of sending it back and recognizing in some of these cases that what I want to say is that I think we have we have concerns and we don't want to see Hobby Lobby to be expanded, but the court has had, the decision itself was narrow to the closely held for-profit corporations, and we don't expect, and that should not be expanded in the courts. And the accommodation we don't believe that the accommodation imposes any burden on people's free exercise of religion, and we challenge and really question. So as you know, you've seen in Little Sisters and in the Wheaton College that there are objections to the idea of even submitting to HHS or to the insurance companies that you're objecting to it, because that is making it complicit, and that should the accommodation should stand.
Thanks, Kelly. Kent, you're shaking your head. Yes,
No,
you see the
one
same.
one
Yeah.
thing that I think we don't know yet is whether state courts applying state RFRAs will map the same rationales as the court did in Hobby Lobby. And by what I mean by this is that if the rationale that the court sees the interest of the shareholders as one with the interest of the company, that in fact the companies, when you say can a company be a person under RFRA, what you are asking is whether the company carries the religious exercise rights of their shareholders. If that is a rationale that state courts pick up on, which I think is probably likely given the nature of the argument, then we can multiply this by some factor, because we've got all these state RFRAs that are probably even broader than this one.
They're not really any broader, but there are 32 states with either a RFRA or the RFRA standard in their state constitution. And let me also just note the nonprofit claims that say we can't even be required to send the notice are so far 0 for 4 in the courts of appeals. I think they should be 0 for 4. It'll eventually wind up in the Supreme Court, but they're not winning those cases.
Go ahead, Kelly. Yeah.
Oh, I just
Yeah.
wanted to kind of jump in though on the state RFRA claim. So we are seeing, and we are seeing kind of a renewed interest after Hobby Lobby in passing in state RFRA claims. So we've had 16 states in 2015 introduced RFRAs, and they passed in two places, as well as kind of more narrow exemptions to various laws. And these are often being motivated, as we saw in Indiana, when they talked about what the RFRA standards were and why they were motivated by Hobby Lobby, by this idea that, well, we need to have these same kinds of exceptions, and that we specifically need to be able, we don't want to require that companies provide contraceptive coverage. And states have already many states have contraceptive equity laws that require insurance plans in their states to include contraceptive coverage. And as we are seeing we're seeing the RFRAs passed sometimes in specific, or seeing RFRAs introduced in specific response to the idea that we somehow want to take back and step back away from rights that we had agreed on were important previously.
Does when you mention Indiana, does it help you or hurt you so much attention now given on the same-sex marriage issue and what people would use RFRAs for at the state level on that? When are you seeing it coming in terms of advocacy? The challenges that you would face, are they similar to people who would be fighting any kind of reaction to a nationwide right to same-sex marriage?
So we are seeing, the challenges, what we have seen in the state RFRA practice has actually in some ways been really heartening, because people have stood up and have rejected the idea that we should be able to use our religion to discriminate. And the fact that people's opinions of where they stand on marriage equality, and not just marriage equality, but where they stand on the idea that companies and people should be able to refuse service and refuse care to LGBT individuals has been part of the narrative. And I think that is helping us in that it's opening the discussion and letting us come back to and start talking again about whether or not and why it is that we have in the past said that it's okay to refuse reproductive health care. And this is an opportunity to start talking about and thinking about what those refusals and what the idea of denying reproductive health care to women really means.
Thanks. Doug Nijay, what do you think in terms of what might happen for the traction for opposition to what I think most of us in this room probably believe is about to happen, is that the Supreme Court will declare a nationwide right to same-sex marriage, and how that might intersect with what you've been seeing in the States?
Yeah, so I should start by saying, as Bill Eskridge was noting yesterday in this room, that we should also wait to hear what the court has to say before, I guess, we get too far ahead of ourselves, and who knows what's going to happen. But let's move forward on an assumption that we'll have at some point in the reasonable future a nationwide right to marry for same-sex couples. I think an important thing to keep in mind is that the fights over the anti-abortion and anti-LGBT, anti-same-sex marriage fights have been related by those invested on that side of the issue, and have been tied specifically also to claims for religious liberty. So there's, at the same time as there's a strong anti-abortion position and a strong anti-same-sex marriage position, there's also been this pivot towards, if the law moves to, well, in the abortion context, has recognized a constitutional right to abortion, and if in the marriage context recognized a constitutional right for same-sex couples to marry, that there should be religious liberty exemptions from those kinds of laws. And so it's important to understand this within that broader political conflict. If we get a nationwide right for same-sex couples to marry, another important thing to keep in mind is that in the majority of states, there isn't an anti-discrimination law that includes sexual orientation. So, and right now, I think the state RFRA map actually sort of looks, in some ways, there are some important exceptions, but in some ways looks like the inverse of the sexual orientation anti-discrimination map. The states that have non-discrimination obligations on private employers, property owners, and public accommodations are a lot of the states that don't have the RFRA standard, and then a lot of states with the RFRA standard don't have anti-discrimination obligations. The thing that was kind of amazing about Indiana is that entire fight was framed around discrimination against same-sex couples, when in fact, if you're outside of Indianapolis or Bloomington, there aren't protections for same-sex couples now. And even the proviso that was introduced into the law doesn't do anything to actually change that. So there will be an ongoing fight. The thing that's happened up to this point around marriage is that the states that actually had moved, and the state-by-state strategy for same-sex marriage, those states already had anti-discrimination law in the books. So it wasn't surprising that if in Massachusetts, when same-sex couples get a right to marry, then you have this conflict between anti-discrimination law and religious objections. And in a lot of other states, now that those states are moving to marriage under federal court order and not having had progressive things happen around sexual orientation, non-discrimination in the state that would lead to an anti-discrimination law, there isn't that obligation. So it's interesting that we've been pushed into this register. Actually, if you, the Williams Institute data on people thinking that there's non-discrimination for LGBT people shows that it's higher than 65-70% of the nation thinks that that obligation obligation already exists, when in fact it doesn't. What we've also seen through Williams Institute data is that states need to be in the supermajority of showing that there's support for non-discrimination in order for us to see a state actually have an anti-discrimination law that includes. So that will be an ongoing battle, and religious exemption is going to be part of that. It's going to be tied up in it, but I think we shouldn't lose sight of the sort of first order question of whether a non-discrimination obligation is going to exist in the first place.
Right. Doug, you've been working on that. Is there a model that you hope comes into being and that most states end up adopting, given depending on what the court says?
Well, so in the blue states, it's over, right? Because they already got marriage equality, and they've already got non-discrimination laws, and they've got whatever religious exemption they have, and most of them have some for religious nonprofits, broad or narrow, and that's it. The religious side has no bargaining leverage to broaden those exemptions. In the red states that still have to pass non-discrimination laws, there is an obvious bargain to be done. And Utah is a model, but Utah also shows how difficult it is, right? So Utah, which regularly reports the highest vote for Republican candidates for president, now has a statewide sexual orientation and sexual identity law for employment and housing, and it exempts all the religious nonprofits and it exempts the Boy Scouts. They could not agree on the public accommodations piece, and they didn't get that done. And it was immediately denounced privately by the religious side, by Republican legislators, and more publicly by the gay rights side, saying it's only for Utah, it's not a model for anywhere else. It's very difficult to do those deals. But the path to non-discrimination laws in red states is religious exemptions. On the for-profit side, hardly anyone and no one sensible is claiming a right on religious grounds. I just don't serve gays. That's not what the issue is. The issue is about weddings, because the wedding vendors understand the wedding to be an inherently religious ceremony. Even if for the couple it's a secular ceremony, because they understand marriage to be an inherently religious relationship. I would exempt the very small businesses where the owner is personally involved in the wedding industry, but so far that has not happened anywhere. Maybe it'll happen in some red states, but I don't expect it to happen. I think it should happen. The other group I would exempt is relationship counselors, marriage counselors, and there has been some litigation about that at the university level and graduate programs and so forth.
Joan, can I just say one thing?
Yeah, of course.
So
yeah.
it's important for us also to be attentive to where the idea that there's a marriage objection or a wedding-related objection can bleed into sort of more generalized discrimination against same-sex couples. And so, for instance, if you think about employers, the objection might be to same-sex marriage, but if it's an objection to providing spousal health benefits, that's a long-lasting objection over the course of the gay or lesbian person's lifetime or working lifetime. And so I'm not persuaded that there's clear lines we can be drawing between things that can be cabined to the idea of an objection to the marriage versus the objection to simply living out one's sexual orientation identity.
Can I jump in there too and just
Yeah.
say that we see, because we've seen that exact scenario and the problem when we look at the healthcare refusal context, and the way it has bled into originally, it was just, well, this particular pharmacist won't have to prescribe emergency contraception or won't have to fill an emergency contraception. And then that has bled into, well, maybe the cashier doesn't have to provide it as well. And that's the same kind of long-term, people can't get the care that they need, that I think is analogous to the risk we run when we start trying to cabin off and say, oh, well, this is just denial. This is just about this is just about a wedding, and it's not going to be in all of these other contexts. But that's not what we saw in the healthcare context.
Let me just take one little detour before we open it up to everyone, away from the corporate context to the official context and opt-out laws. We just saw the action in North Carolina, and in Alabama we have like Roy Moore on behalf of everyone opting out there. Could those have any future? I mean, do we see those as possibly being constitutional in any way, to have officials opt out of doing marriage if court upholds a right?
Well, the North Carolina bill is not perfect, but it does require that someone be available to do the wedding, and it does require that somebody be available to issue the license. So I don't think there's a constitutional problem with it. I don't think it's going to be enacted in many places. There is a similar provision in Delaware in their marriage equality law, but those are the only two that I know about.
Anybody else have any?
We
view on
are
that?
seeing a proliferation of these kinds of opt-outs in targeted areas, and so these bills are being tracked across multiple state legislatures, and some of them will get out and we'll see where they go, but I don't think right now we have a great sense of how much traction they're going to get versus more going through generalized religious liberties bills. But certainly they're proliferating, and one area in which they are proliferating, and Michigan is a good example of this actually passed, but this exists now in multiple state legislatures, is in the adoption industry.
Oh, yeah, right, which we just saw.
Yeah.
And do you agree that if, as long as somebody in the office can officiate or give the license, that they'd be constitutional?
So my concern here is not just with whether I can actually go get a license, but how the state is actually treating me as an equal citizen. And I think maybe we'll get some guidance from the court in a marriage decision that tells us more about the standing of gay and lesbian people in society. But the idea that I'm being denied the same type of service that other people might be denied because of sexual orientation is troubling. Now, the law in North Carolina does not single out sexual orientation or single out same-sex couples. So as a constitutional matter, I think that makes it a more difficult question.
And the other interesting thing about North Carolina law is if you don't do same-sex marriages, you can't do anybody's marriage. So,
Okay.
so you got to opt out entirely. And
For
so
6
there's
months, I think, right?
for 6 months, yeah. And then if you come back in, you got to come back in for everybody or nobody.
Great, well, thank you. Does anybody else on the panel, have anything to add before we open it up to everyone? Great. Okay, so either go to the microphone, or do we have somebody who's passing a microphone, or is it best just to, Kara, just to the mic? Thank you.
Hi, Greg Lipper with Americans United for Separation of Church and State. I'm wondering about the relationship between complicity arguments and sincerity challenges. If, as what seems to be happening, the court goes increasingly deferential to what seem like very expansive complicity arguments that to some of us look like sort of imposing one's views on another, will we see an increase perhaps in challenges to the sincerity of religious objections that we haven't seen thus far? For instance, in a company like Hobby Lobby that actually covered the very devices that they claim to be objecting to. If one gets easier, will the pushback be greater on the sincerity context?
Justice Alito can be read to have said in Hobby Lobby that the court simply can't question the substantiality of the burden. If that's what he meant, he's going to have to back off on that. That's not a workable standard, and some of the lower courts have more or less said that and continued to examine substantiality anyway. I think he's right to say the court should defer to good faith religious assessments of the substantiality of the burden, but the courts have to police the boundary, and I think they are much more likely to continue saying this burden is not substantial. They can treat that as a question of law than they are to start interrogating sincerity, which is hard to evaluate and a question of fact. What the courts actually do with sincerity claims is they weed out the obvious con men, and they categorically reject claims where the alleged religious belief aligns too closely with self-interest. So if I say I conscientiously can't pay my taxes, I may lose on sincerity, I may lose on compelling interest, I may lose on burden, but I'm going to lose, and we know that from experience over 30 years in the cases.
So one thing that the corporate aspect of the claims will add to the difficulty of the sincerity argument is that because the operation of these exercise or RFRA claims exempts the corporation from otherwise applicable regulations, there's going to be an economic incentive to claim them, right? And if a corporation is acting with that economic incentive, you're going to have a lot of claims. You're going to have a lot of road to Damascus experiences in the boardroom. Like, we want to get exempted from this, that, or the other. Now, if Doug is right that courts are very reluctant to see sincerity when it maps with self-interest, then these claims may not explode. And one of the reasons why you might not, I agree with you that Hobby Lobby actually had been paying these things, and so you could have questioned the sincerity in Hobby Lobby. But because of the nature of contraception and insurance, they didn't get a big economic payout from refusing to do this. It's probably a wash economically.
And I think that the shift wouldn't be from substantial burden to sincerity, and instead, and I think Justice Alito can be read in Hobby Lobby as being really deferential on the burden question, and also sort of from an institutional perspective, saying courts shouldn't be looking into this, and that doesn't seem faithful to what the RFRA standard really is. But as a sort of legal realist matter, then we're probably shifting to that inquiry about compelling governmental interest and narrow tailoring. That's why we're really looking at that aspect and how the harms factor into accommodation there. And other scholars are arguing that maybe really if substantial burden and then the burden that the claimant carries doesn't really have any teeth, that the strict scrutiny that gets applied on the other side might be ratcheted down by courts as well. And I think we're just going to have to see how courts end up applying that standard in future cases.
Thank you. Go ahead, sir.
Yes, hi. My name is Stephen Spitz, and I took corporate law at the same law school as Doug Laycock and Kent Greenfield. So my question is to Doug Laycock. I don't understand how a corporation, which has been established in order to separate itself from individuals, can then have the individuals transfer their religious beliefs to this artificial entity that limits the liability of the individuals. How can you have it both ways?
Well, look, we're not interpreting corporate law here, we're interpreting a religious liberty law. And I think Kent stated it rightly at the beginning. The question here is, did the Greens forfeit their right to religious liberty when they incorporated their business? And I don't think that would be a sensible interpretation of RFRA. There is a body of law, I don't know it very well, but there is a body of law on reverse veil piercing that deals with exactly this kind of claim. But from the purpose of the Religious Freedom Restoration Act, the Greens should not forfeit their rights. And excluding religious minorities, especially Catholics in England and Ireland, excluding them from various businesses and professions is a time-honored form of suppression and subordination, and we shouldn't bring it back by saying as soon as you incorporate your business, you lose all your rights to religious liberty.
Kent, do you want to respond to that?
Yeah, as a fellow University of Chicago grad.
I think the question is not really a RFRA question, but a corporate law question. One of the dogs that didn't bark in the Hobby Lobby opinion is they're looking to the underlying corporate law assumptions in Oklahoma, right? Hobby Lobby was incorporated in Oklahoma. It should have been relevant what the assumption of that body of law was. And so I just simply disagree that the very purpose of the corporate form is separation. If you want to be unified, don't incorporate. You can have other business forms.
Thank you. Yes.
Hi, I'm Nancy Marcus. I teach law in Indiana, and I had to clear up a lot of misconceptions about Indiana's RFRA when it first came out. Because if you look at Indiana's RFRA side by side with the previous versions of RFRA that were based on the federal RFRA, there are differences. It is extremely broad, and it adds some new language. And so I'm calling Indiana's RFRA and other ones based on it like the second wave of RFRA. Because what Indiana's did was not only did it have language that said that it applies regardless of whether or not the state's a party, but it also had a definition of who could file for basically relief under RFRA. And the definition was very broad and said this applies whether or not it's a person, a corporation, a business, any entity or organization. Huge definition of who could have a RFRA claim. So that is new. It's a new form of RFRA that we're seeing. And so I just wanted to clear that up. And then I had a couple questions. One for Doug Laycock. Correct me if I'm wrong, but I think I remember that you filed an amicus brief in the pending Obergefell marriage case that basically asked for the court to provide some kind of religious exemption if it's going to allow marriage equality. So I was wondering if you could expand on what kind of religious exemption you would like the court to put into its opinion. And then a question for the broader panel as to how you interpret the Hobby Lobby language in dicta where the court says, well, okay, this isn't going to be used to justify discrimination, but then the court goes on to say, because race discrimination is something that we're concerned about. So you have this one sentence that doesn't specify race discrimination, and then another sentence that does, and how do you interpret that?
The definition of person in Indiana RFRA was basically the definition in the Federal Dictionary Act. So this was a change in form, it was not a change in substance. What a group of us, 5 individuals, said in an amicus brief in Obergefell is not if. We said the court should protect marriage equality nationwide as a matter of constitutional law, and it should clearly signal that it understands the religious liberty issues that will follow in the wake of that, and it should take responsibility for those religious liberty issues, because once you do marriage equality constitutionally instead of leaving it to legislatures, you deprive the religious side of any legislative vehicle or any bargaining leverage by which they might negotiate for exemptions. So the court will have to do it for the religious nonprofits, and we said for very small businesses in the wedding industry and for marriage counselors. I don't expect to get all that, but that's what we laid out, and we laid out doctrinal means by which it can happen.
Does anybody want to address the discrimination question? Doug?
Yeah, so this is the passage of the court's opinion in Hobby Lobby where Justice Alito says, what about other kinds of cases? Partly Justice Ginsburg is raising issues including Elaine photography involving sexual orientation discrimination in her dissent, and Justice Alito says there's other contexts in which our opinion wouldn't allow for an exemption, and cites non-discrimination citing race discrimination. The challenge for folks going forward is really to be able to establish the compelling governmental interest in eradicating sex and sexual orientation discrimination. The Hobby Lobby decision wasn't articulated in the Register of Sex Discrimination or Sex Equality, and to a large extent also wasn't litigated in the Register of some of the harms, including dignitary harms to women. And so in the non-discrimination realm, that's important. We'll have to see how it plays out. There are a lot of cases emerging, or some cases emerging, involving sex discrimination and issues related to pregnancy. And we also are obviously having sexual orientation discrimination. So it certainly is a challenge for LGBT advocates and sex equality advocates to be able to make the compelling interest arguments. And I think Hobby Lobby certainly leaves room to do that. It's just a matter of future decisions.
Kelly, do you want to add?
Yes. So I think that's right. That part of the problem, and that I wanted to kind of highlight in my original remarks, is that the way the idea of the compelling interest was framed was to just say, well, we're talking about contraceptive coverage with no cost sharing, rather than thinking about how this benefit was designed. And the ACA deliberately set up that, for better or worse, we have insurance in our country that comes through our employer health plans. That's part of our compensation. And it was set up to ensure that women's preventive services were covered with no cost sharing. There's the specific Women's Health Amendment from which the contraceptive coverage requirements came. We wanted to make sure that women had access to that care that was coming through their employee benefits plans. That was part of the structure of the ACA. And so the way that the majority opinion kind of conceptualized the compelling interest left off all of those ways in which there was both dignitary harm to women when you cordon off and you take contraceptive coverage, when you take their health care and put it in a separate box, as well as the harms when you say that their compensation doesn't have to be the same. And so, but I think going forward, when we're looking at what that compelling interest is, that's where we need to put some meat on the bones and really push forward through with that argument.
Thanks. Yes.
Hi, I'm Catherine Barry, and this is maybe a bit of a higher level question, but when I've raised arguments similar to maybe what Kelly or Douglas are saying, third-party harm, I've gotten from Federalist and my conservative cousins at the Thanksgiving dinner table that I am being anti-religious and anti-Christian, and I was just wondering if the panel could give me any guidance of how to respond to those.
Well, I think if your position is that no interests progressives care about should ever have to face the slightest risk, even at the margin of any infringement, whatever, you are opposed to religious liberty, you are being anti-religious. These cases are about to what extent can we protect the rights of both sides? And we can protect the rights of both sides to an enormous extent if neither side insists on perfection. The problem is, and both sides do it, both sides are utterly intransigent. They want a total win in which we get everything, you get whatever's left over, and any ambiguity or risk at the margins, we get that too because we can't be made to take any risk. That's not consistent with individual liberty, and it's not consistent with the secular liberal tradition.
So there are some liberals, right, who take the position that laws of general application shouldn't be deemed to have religious exemptions or accommodations. And I think you can have a liberal or progressive position that actually recognizes the importance of religious liberty and accommodation, and actually says that generally applicable laws can still burden people in ways that we actually think should be accommodated. And I think that's a position, certainly that's the position Riva and I are trying to take, in which we see that the cause of religious liberty and the cause of accommodation is a liberal cause as well, but to recognize some principled limits on accommodation. And I think the idea of harm to third parties and how we're going to differ in the way we work that out, but thinking about that as a principled limit, not questioning the sincerity of the religious claim, and not questioning, even to some extent, a burden in some circumstances, but then thinking about how you work out accommodation, I think is a way you can be both respectful of religious liberty and principles of accommodation, and at the same time respectful of the interests in equality, both sex equality and LGBT equality.
Yes.
Hi, my name is David Melton. I'm a retired lawyer, now executive director for a nonprofit in Illinois. I have a concern about the degree in which, to my mind, the Supreme Court, not just in Hobby Lobby, but in a variety of cases, is allowing, in my view, the free transfer of constitutional rights from individuals to freely transfer those to their corporate entity and disregard the separate corporate form for that purpose, but it's not allowing the same thing in reverse, so that when it comes to the corporate distinction as a separate entity for jurisdictional purposes or for disclosure purposes, they're very solicitous of the difference between the individual owners and the corporations. I see that as a fundamental disconnect, and in my view, Hobby Lobby is another illustration of that inconsistency. Am I wrong in perceiving that that's what this court is doing, is giving corporations the benefit of rights without making them assume the corresponding responsibilities that the individuals have?
Kent, you want to take on the bigger corporate question?
Yeah, I think that's right, and that's basically my analysis. I mean, here's where the analysis might get difficult, and there are these things called benefit corporations, right? And they're now available in the majority of states, and it's actually a liberal idea, or started as a liberal idea, and it allows corporations to be chartered for both financial reasons and to choose other reasons. Patagonia, for example, is a B corporation, and they say in their charter that they're that they want to be making money, but also want to act consistent with environmental purposes. And so the question is, could a company incorporate as a B Corp and say that what they want to do is to serve traditional marriage, or to be a religious company? Rick Santorum announced his candidacy 2 weeks ago at a factory in Pennsylvania that articulates itself as a Christian company. So I think the difficulty here is what we do with that kind of entity. Now, I agree with you that if it's just a transfer of the shareholder interest to the company, it's an easy no for me, because of the waiver of those rights really should come as a condition of incorporation. But I think it's a harder question when it's not really a matter of shareholders, but a matter of corporate personality and corporate culture itself. And so, to step back just for a moment and very quickly, there's been an interesting flip between the conservative view of corporations and the liberal view of corporations. For a long time, it was those of us who are on the left side of corporate law to say, look, corporations should be more than just about profit, right? Corporations should be good citizens. And it was the right-wing corporate law views that shareholders Profit should be the only thing that matters. And now we've got an exact switch. After Citizens United, it's the left that's saying, let's protect, let's cabin corporations within a small area in the public square, just to be about making money. And it's the right of center folks that say, no, corporations should be about more than that. In fact, Alito cited the existence of V corporations in his opinion, that corporations should be about more. So I think there's an interesting tension now about those matters.
Thank you. Yeah.
Hi, Peter Montgomery, People for the American Way, one of the original sponsors or backers of RFRA. I wanted to say that I think one of the reasons that progressive and LGBT groups have now really backed away from the state RFRAs is precisely the knowledge that Doug Nijame and Kelly Garcia were talking about of how expansive the rights claims on religious exemptions have gotten in the reproductive health care, that it's from one thing to the next to the next, the really tenuous connections to the original objection to an abortion procedure, and the concern that if you carve out this legal principle that complicity in a wedding, it's going to open that same kind of really expansive undermining of the things that the LGBT movement has been working for. And I guess I'd like to know what reassurances you would suggest that what you're seeking is not going to open that kind of door.
Well, the expansion you talk about has been done by legislatures. The judicial history of RFRAs has been extreme disappointment for their supporters. Chris Len collected all the cases in 2010. The South Dakota Law Review, Chip Lupa, who generally didn't like RFRAs, updated it last year. And there have been a few wins in non-controversial cases about feeding the homeless, about grooming rules, about autopsies, a few other categories, Amish buggies. Most Americans never heard of RFRA before Hobby Lobby, and they never heard of state RFRAs before Indiana, and that's because they've not done anything constitutional. The judges have been extremely cautious, and I think even Hobby Lobby is consistent with that because of the narrowness of the opinion. But to the extent it's not, Hobby Lobby is exceptional, and it's misleading to focus on Hobby Lobby. The language in the abortion conscience statutes is specific, and it's as broad as legislatures make it, and judges have to deal with that. But the language in RFRAs is very broad. It leaves a lot of discretion to judges, and judges have been extremely cautious, and we have now 50 years of experience with that since Sherbert in 1963.
So I think the question raises an important idea, which is that sometimes we introduce the concept of religious accommodation or exemption as a way to settle or resolve ongoing conflicts. And I don't have confidence that what's happened in the abortion context gets replicated in the marriage context, but at least we can look to what's happened in the abortion context as a cautionary tale. And what you saw immediately after Roe was the Church Amendment being enacted with near unanimous support by Congress to allow conscience injections by physicians or nurses from having to perform abortion or sterilization, and over time, in the ongoing political conflict over abortion, you see that expanded and expanded and expanded. So I think it's a legitimate concern. So for folks who are interested in the LGBT equality issues and they see the exemption being put forward as a possible mode of resolution, lessons can be learned from the abortion context to see that it could be a way of, rather than resolving an ongoing conflict, to allow a right that is about to be secured for LGBT people to actually be chipped away at over time. I don't know, but I think that's an important thing for at least us to be thinking, and maybe question a conflict settlement function that we think that exemptions might serve.
Can I also jump in? And I just want to say that I don't think we can just dismiss. I think we need to be very cognizant and careful and thoughtful about the fact that yes, this is coming from legislation, but the legislation matters, and that it's setting the context for what's going forward. And not just the context, it is setting the way people's rights are going to be recognized. And we're a year post Hobby Lobby, and what we've seen a year post Hobby Lobby is this renewed interest in passing state RFRAs, this renewed interest in looking at and admittedly on both sides, looking at these conscience clauses and looking at these refusal laws, and that's important, and it matters, and these battles really matter and we need to pay attention to them. And I don't think we can kind of cap it off and say, well, it wasn't the courts that did that, so it's not really the issue. No, I think that is very much the issue that we're seeing now.
And just to follow up on that, there's a jumping over. So the objections in Hobby Lobby, before Hobby Lobby, there was attempts to get the Blunt Amendment passed, which would have provided the same kind of accommodation that was secured in court through RFRA. And so we do see that there's a relationship between legislative attempts at accommodation and now potentially judicial attempts. So now, given that Hobby Lobby is a year old, we'll have to see what kind of life it has. But I'm not persuaded that we can draw that strict distinction.
Thanks. Yes.
Justin Woods, I'm the president of the Pace Law School ACS chapter. And we had a debate with the Federalist Society. They brought in conservative, quote, scholar, Professor Keith Duncan from Nebraska. And he was pretty out there saying that putting Hobby Lobby in the context of civil rights and kind of embodying this concept that, you know, God's law is more important than ours, and this is really adopting the framework of civil rights to discriminate against gay and lesbian people, against women's choice, and all these issues, and it was really troubling. So I'm curious what your thoughts are of kind of these discriminatory tactics being framed in a civil rights framework, and why we elevate this concept of religion in a secular society to being even more important than someone else that has principal beliefs that aren't in religion. So if we have objections to, say, certain vaccines, but we can't put our kids in public school, if we're for religious, then you don't have to do it. But if we're based on science and independent verified tests, well, you still have to put the poison in your kid, and you can't put him in a public school.
It's Rick Duncan at Nebraska, and he's pretty far out there. But the basic point you attribute to him is right. Religious liberty is a civil right, and it doesn't mean that you should be allowed to inflict significant harm on others. But to the extent we can exempt religious folks from participating in some of these things, and still make marriage equality and reproductive health care available to the other side, we ought to provide the exemption. It is a tough sell to legislators to make a RFRA generally applicable to secular objectors as well, but in the context where secular conscience objections actually happen, we have mostly protected them. We did it with respect to the draft. All the abortion conscience laws and the assisted suicide laws protect secular conscience objectors as well as religious conscience objectors.
It's an interesting phenomenon that you're picking up on, which is the idea that in ongoing conflicts, it's often we see people borrowing the strategies of their opponents, and it's certainly not the first time that we've seen conservatives use liberal frames to justify their ends. And so the frame of non-discrimination and civil rights is a very powerful frame, right? And it's especially a powerful frame to respond to a competing claim of non-discrimination. And so we've seen this shift in argumentation. And so if I can get the law to actually ban same-sex marriage, then I might want the law to do that. And in the absence of doing that, I can shift to seeking exemptions from laws in the name of non-discrimination and civil rights, which might give me some of the things that I wanted from that but couldn't get. And so we're seeing that shift, and it's a very powerful form of argument that we should pay attention to.
Thank you.
Thank you. And your timing's perfect. We have just right for one last question.
Hi, Imani Gandhi. I'm a senior legal analyst at RH Reality Check, also 2001 graduate of UVA. My question is about at what point do religious liberty interests have to be conceded when it comes to issues of what I think actually boils down to bigotry? I think especially today, you know, we're a couple of days out of the anniversary of Loving versus Virginia, and at the time, there were similar arguments made about the religious reasons for which races were not allowed to intermarry. So I'm wondering if you're seeking exceptions for marriage equality. I mean, what would you have said 50 years ago when there were people seeking religious exemptions for miscegenation laws? So that's my first question. And then my second question is more about sort of junk science and what it is that we are supposed to allow corporations to put forth as evidence in court about quote-unquote abortifacients, right? So a lot of people think that emergency contraception is an abortifacient, and there's this new growing movement for people to think that things like the birth control pill is actually an abortifacient. And so if we're saying that the court is not allowed to examine a plaintiff's or a litigant's sincerely held beliefs, if those sincerely held beliefs are just factually inaccurate, then are we saying that the Supreme Court is not allowed to say, okay, look, you can sincerely believe that emergency contraception is going to induce abortion, but the overwhelming medical consensus is that that is not the case. So how do we, what do we do about plaintiffs and litigants who want the Supreme Court to enshrine basically junk science?
Well, this junk science comes off the FDA-approved label, the FDA-required label for emergency contraception, which says it may act by preventing implantation.
Right, but
so the religious conservatives didn't make this up.
Right, but I mean, the overwhelming medical consensus is that FDA label is wrong, and there has been a movement to try to get that label changed. So, for example, if that label is changed, so let's assume that hypothetically that label is changed. Are we still going to allow litigants to say, well, we sincerely believe that this induces abortion when it doesn't?
Well, I think we will unless there's at least until there's a clear scientific determination. The consensus became a whole lot stronger once Hobby Lobby began to get publicity. I've looked at those studies. I'm no expert, but they sure seemed ambiguous to me. The data seemed ambiguous. On the other question about race, you could not grant exemptions on race in the 1960s because it would have been nullification in the entire South. And I do think race is constitutionally unique in our history. We've treated gays terribly, but there was not 250 years of slavery, there was not a civil war, there were not 750,000 Americans dead, and there were not 3 constitutional amendments to fix the problem. On the religious side, teaching about sexual ethics has been central to religions for essentially forever, in a way that the Southern teachings about race had never been central, were sort of created for the occasion. So I think there are all sorts of reasons to treat these issues differently from race.
Doug or Kelly, you want to jump in on that, including on the FDA standard?
Sure. So on the Samani, you're right. I don't know what else to say. You're right. We have a good scientific evidence that it's not an abortifacient. There's the evidence and the data are there, and it's a real problem. It is very challenging when we're talking about any of these things where we have science on our side and we're asked to debate science versus belief, and we're told, well, we don't get to use the science because belief is going to trump, which is what it feels like is what's going on here.
And there was a report out of Guttmacher about this phenomenon of labeling some forms of contraception as abortifacients, and so both showing that sometimes the religious criteria that are supposed to be deployed are not used accurately to label some contraceptions, and that when the religious criteria would apply to some commonly accepted contraceptives, that it's not labeled an abortifacient. So it suggests there's some strategic reasoning happening around that as well. The issue around exemptions and the relationship between religious beliefs and bigotry is one we've dealt with historically. And I think one important thing to keep in mind, which Bill Eskridge talked about yesterday here, was the way in which faith groups are actually shifting their views on sexual orientation. And so I think we are seeing that, and we will continue to see that. And it's important for us to recognize discrimination, but it's also important for us to allow some ongoing conversations to happen within faith communities, and also to recognize that there's differences between faith leaders and leadership versus people on the ground who are practitioners of faith. And I think we're seeing, even within the Mormon Church, we're seeing a lot of resistance that's important to keep track of. But yes, this is something we've dealt with before, and part of the position of a lot of LGBT equality folks is to say we shouldn't be treating sexual orientation differently than we've treated race or other protected categories. Partly why the Utah law was a successful compromise is because Utah has carve-outs for sex and race that other states don't have, and so LGBT groups were willing to go with that, but don't view that as a model in other states where sexual orientation would be treated differently.
So I've got a test case about the junk, on your junk science point. As it turns out, disbelief in climate change, for some reason, maps really closely to religious beliefs of some kinds. You could imagine a closely held energy company owned by a very religious set of shareholders saying that they have a religious objection to obeying EPA mandated rules based on climate change science, right? So, and in my view, there's nothing in the Hobby Lobby opinion that would bar that claim.
Okay.
Thank you. And I want to thank the panelists for their insights and how concise they were. We're finishing up right on time. Thank you again to Kelly, to Doug, to Kent, and Doug. And